Good afternoon, ladies and gentlemen. Thank you for this opportunity in CICL 2023 conference on innovation and communication law. The title Marketplace for Innovation Ideas and Technologies, Role and Responsibilities, organized by Adam Microsky University. It's my pleasure to share my research on utility model informatics and how we apply the re-examination validation decisions to predict the patentability, and how could these decisions and this performance based on AI machine learning could be applied for patent strategy management and commercial use. This is my research partner, Dr. Chou Huizhong. I'm Mei-Hsin Wang from National University of Science and Technology. I'm also the fellow of Royal Society of Chemistry. This is the photo and images about Taiwan and my university. First, allow me to address the good intention from my university. We have quite a few prestigious ranking among the world. We would like to address our good intention. We are hoping in the future we could work with all of you with mutual commercial benefits, which not only good for our research, teaching, industry cooperations, but also benefit for both university faculties and students as well. As you can see, we have organized many events academically, commercially, with industry, patent offices, and academics, universities, organizations, research institutes. And we hope we will be getting more and more friends after this presentation to make friends with you. We can publish papers, books together with real business interest. First, allow to me to address the difference and the similarity between the patent and real estate. Actually, there are many similarities because patent and real estate, they are the assets that can be sold, they can be priced, they can be loaned. Of course, they need to be registered, they have their legitimate position, but however, patent are intangible assets. They have the limited period of time. They will be expired if you don't pay the maintenance fee. Even if you pay the maintenance fee, they have the limited period of life cycle. But the real assets, they will not expire, like house or land. But patent rich deal in pharmaceutical and in many industries that does show remarkable outcomes, as you can see in these few cases. A couple billion deals, multi-billion deals between patent-rich companies. They happens all the time. Patent litigation, that's also the measures how we can benefit and get return on investment for our patents. Certainly, patent can be licensing. So the royalties from different industry have their principles, rules. Definitely, patent can profit and pay back to the inventors. The most interesting, the new financial tools, they are patent securitization. They are quite famous university research institute that have demonstrated how they apply their patents to securitize the securities. For example, I use this Emory University case. They have the hepatitis medicine, FTC. Actually, they have the mother molecules, and they licensed to Boehringer Wellcome first. Then the Boehringer Wellcome were acquired by Glaxo Wellcome. But later on, Glaxo Wellcome, they find a similar methods from biochem. Normally, industry they would require for the exclusivity, so they prefer working with company, and then they come back to try to revoke the patents of the university. Of course, Emory University wouldn't be happy. Therefore, they hire their financial consultants, very famous firms, and they also hire 40 attorneys through 6 years of litigation, negotiation, and finally settle. So it's a complicated case. even the patent, they under litigation, they could be securitized. Securitized, they normally they went through the mechanisms. They have been removed to special purpose company. The companies they will design the programs. And also they have the issuer to issue the bond, and they have the plan, and they have the risk remote mechanism to protect the investor. So the investor can invest on patents, but the patent they must have some existing royalty stream, or they already have some solid income. For example, in this case, that's your university's formulation for AIDS, for treating AIDS, and it's already being licensing to Bristol Script, which is late top 10 pharmaceutical company. So you can be sure that this patent will continue to generate very stable income. On the security purpose, it could be for develop new indications, carry on clinical trial, building pharmaceutical manufacturers, or marketing purpose, or on the cooperation, develop new formulation or new treatment methods, whatever. But during this securitized periods, they must follow their original plan, and during this time, whatever they earned, and they at the end of the securitized periods, they will pay back to the investor. The special purpose company will monitor and perform all these programs. What's the difference between the investment and or securitization? Securitization is not investment, it's not a sale, so it won't be taxed. And if you use your land, your house to borrow the money from the bank, normally you can't have the full value of your land or your house, but securitization, you will get your full price, your full amount. But nevertheless, it wouldn't be. You don't need to pay back even you fail, because if you following the plan, they have a bankruptcy remote mechanism to protect investor. They have insurance systems, so it's a complex place. So patent could be treated like the tokens, like the virtual currency recently. It's a legitimate right, be recognized, be issued by the countries which you have applied. Therefore, here we would like to address is that there are coming a new IP ecosystems. It was backed by many emerging technologies. It could be AI, machine learning, blockchains, whatever. So since all these big data, informatics, and this machine learning technology, artificial intelligence, so they make a lot of information transparent, and they make people who are interested in the patent, they could invest. Even insurance companies, even whoever who have interest in this intellectual property rights business, they could participate. AI, artificial intelligence, machine learning, big data analysis, predicting technology, they have changed not only intellectual property rights, but it also changed the legal practice for us daily. In those days, we did our day's work to prepare our case, but nowadays you could have this big data analysis, quickly have very precise percentage whether you will win the case within how many days, what is the average of damage amount, or they help you to prepare your arguments, to manage your case, your business more intelligently. That's without the words. There are already many mature database, for example, .ip, which have been acquired by Clarinate. Even you clicking and typing some products or the company names, you can quickly get the global litigation histories, the reasons why they were under litigations, the winning or losing situation, the grounds. They will be very helpful for you to prepare your litigation and your enforcement conduct. It's not only happen on the patents, it's also for trademarks, because they are, if you look at these bottles, it looks all similar, but when you look closely, those trademark actually different. The perrier, the sexier, the crazier, the fruitier, the sexier. If the patent, if the trademark examiner look at these words, it would be difficult for them to identify they are the potential infringer. But with AI, they will help you to find the similar arts, the similar marks, just a few clicks, and in few minutes, they get you the global information. Even the courts, they now apply AI for their daily practice as well. Of course, those AI big data technology, they must based on the theories, algorithms, the principles, but which we shouldn't worry too much. We have our human intelligence. It would not be too difficult for us to identify some principle for machine to learn, for the AI to help us. Nevertheless, nowadays, this AI big data technology, they generate reports quickly in few minutes. They could quickly give you the locational wise or criteria wise analysis and charts. That's very meaningful for management of intellectual property. You don't even need to worry too much how can you be familiar with this tool, because you type in few keywords. They have the filters. You can even drag in the images, so you can quickly get all the similar arts with the most similar, or even whether they are active or not, where are their locations, which class they have been applied for the trademarks. If you want to dig in the more details, you just click in. You can know who owns the marks, the current situation, and the categories which have been registered. This tool, Patent Cloud, is what we use to train our students or our first year undergraduates in my university. They all familiar with this tool. They can use this for patent search, design search, even for essential standard patents. They could conduct patent due diligence, quality analysis. We can even do the share works for the team. So for patent preparation, how to file a patent, how to prosecute the patent, how to monetize the patent. We train our students from the first year undergraduates. This slides we would like to show you is the image identification for design search. Now the technology has very much mature and advanced. You can have the image cropping. You can image with keyword. You can have image cropping with specific elements. So you easily find out the similar art globally. Very easy for you to design around or to enforce your rights. Depends on which role you're going to play. Nevertheless, we actually we consider the emerging technology that does reduce the technology barrier and also the language barrier. For example, in the system, they could be expanded to Japanese, Korean, German, Chinese, the most popular languages, and also they could cross link it to the similar arts. Even I'm in the biotechnology field, somehow I may not catch all the similar words at 1 minute. They could give you the reference. cross-language, cross-technology. Give you a reference. Nevertheless, even for the business correlation, they could search and correlate it to the business relations. For example, if we search Sony, the related business with Sony, they will be listed, and you can choose based on your domain knowledge. But however, for this moment, I'm still thinking human being will not be replaced, because the domain knowledge and working experience, they count. Because for the companies, whether they are related or not related, somehow they based on the working experience and domestic situations. Although AI, they could help us, but they need us to train them. And how we use this analysis, because the system, they could generate hundreds of charts, but from each of the charts, for example, this is the legal status. From the reissue pattern, then we would know they were very top pattern, because they have been survive after the third party or their competitors challenges are being reissued. Then we will certainly would like to go into these 167 patents to review their quality, or of course their value will be higher. So immediately they could quickly categorize your overall situation, no matter it's legal situation, or no matter whether they based on the place where you are finding the locational wise, the pattern landscape. For example, Samsung is a international company. They file more than 1 million patents. Without this intelligence tools to support, it will be very difficult to manage the whole patent profile. It's so obvious. This is the shop. Shop it has been invested by this patent crowd founder, because this system was developed by Foxconn, and he had been training all these merger acquisition over 20 years. They could quickly identify patent quality for over 249,000 patents from shop. For the patent value, we train students how to think based on those information, what strategy they could develop. It's not only good for student training, it's certainly very good information for company, how to prioritize their patent life cycle management, and their patent monetization strategy. For example, this is the CAST, the best graduate school in Korea. As you can see, they have very good patent profile based on the quality, but since it's a research institute, they didn't have enough manpower to further monetize their patent. So their high value patent, not them as much as presentable as their patent quality. So there are a lot of the room for us to use this patent informatics to develop commercial strategies. So what we did is we guess the invention, we analyze the claim, we search the prior art. So the strong prior art found, they could challenge the patent claim will be found. On the patent limitation for claim construction could be analyzed by AI and further confirmed by human. Then we are the human to decide what we want to index the patent, we want to license the patent, or asserting the patent. In our paper, we focus on the patentability. For now on, you understand patent sustainability is crucial for patent monetization. Competitors, they often attack patentability. We choose the machine learning models SVM and VPN applied to study the patentability and patent sustainability through China patent, which have been filed in validation re-examination proceedings from 2000 to 2021. We first train our models to predict, and then we perform the testing to test the accuracy, see whether this model suit for this purpose. And the accuracy validation will perform by comparing to the existing re-examination proceeded decisions. So machine learning models training will compare with the existing invalidation re-examination decision. The prediction test will also compare to invalidation re-examination decision. So we could have the accuracy rate, and then we can decide whether we have chosen the right model and right study design. And we apply ANOVA to confirm significance for pattern indicators. Machine learning, of course, model, they provide a classification, model training, and prediction. So SVM, which is a supervised classification, which will estimate classification hyperlink, use the principle of statistic risk minimization. In our research, the Gaussian radial best function kernel will apply in this parameter-based classification to suit our pattern indication. We not only apply SVM model, we think maybe we can also compare to VPN model, because in this statistic field, normally we choose the few suitable models, and then we train the model, we testing the outcome, and then deciding which one will be the best to suit our purpose. So this is our study design. We have overall 21,999 cases from 2000 to 2021. Sorry, this is 2000 from 2000 to 2021. We divided into two groups. And the group one is the pattern all valid or partially valid. And the group 0, they were the pattern, they all invalid. So the cases from 2000 to 2020, we have 20,115 with 11,533 in group 1 and 8,578 in group 0. The cases for 2021, we have 1,884. In this group, we have 956 in group 1 and 928 in group 2. So we use 20 years for training and 1 year for testing to do the comparison. So what we have done is we data mining and data scraping all this data. And we have the statistic confirmation for the parameter, and then we apply our data for machine learning, analyze through our brain. Then so here you see. After that, we have the SVM with RBF for 20 years training and then 1 year testing. Then we also have the 1 year training and 1 year testing. We compare with that to see what will be the best model. And then the third we have the BPN for 20 years training and then 1 year testing data. And then finally, we compare SVM model and BPN model to decide which one will be more suitable for us to decide the patentability. So here are the sample allocations for each year, Group 1 and Group 2. And these are the pattern indicators which confirm significant. They are the international pattern classification that matters for pattern quality. And the claims, how many claims in the pattern, they also concern with the pattern quality. How many figures in the patterns, the wordings in the descriptions and examination durations. These are the parameters which we think will be important for the pattern quality, and actually they have been proved by ANOVA for their significance. Then come to the outcome. First, we can see the SBM RBF training and testing data. The training data for Group 1, which are the valid patterns, were 96.27%. And for the testing group, it was 93.83%. So each performed very well. Then you may ask me why the valid group are more have showing more significant product outcome than the invalid group, because invalid pattern, that means they are less quality. So with the less quality pattern, they have many weaknesses. But for the valid patterns, certainly they have, as we have been proved, they have certain features which we can identify. These are the charts. As you can see, for these valid patterns, they are after the training for 20 years, they show very well outcome. For even an invalid pattern group, they are also improving their outcomes. And for the testing outcome, as you can see, the valid group is the Rule 1. They shows very nice results. For the Group 0, they are also showing growing one. The green one is the average for both Group 1 and Group 2. So the above are the models what we have been performed by SBM. Then we compare with BPM group. It also shows quite presentable outcome. There was 85.68% for training outcome for 20 years. For the testing outcome, 85.25. It also show us indicates that BPM is also a nice model. But however, if we compare with the SBM RBF model, 96%, 93%, they are a little bit higher than BPM. So in this case, it is give us a very good method and very good way. In the future, we can use this machine learning model to predict the pattern in the company, to predict their sustainability, whether they will be survive if competitor send them to these AIA or invalidation, reinvention procedures. So it proved we found a good method for corporate to manage their pattern profile. So after that, the companies, they could decide whether their weaker pattern they want to abandon or they want to sort them out, because so the smart service transaction that could be done by blockchain or many methods. So AI big data support pattern monetization, patentability, sustainability matters. Nowadays, searchable file wrap assistance with validation issues, they over semantic prior search. They could support claim chart creation for invalidation and supplement argument on prior art reference as exhibit. So the AI big data mining machine learning for IP, they provide the actionable pattern intelligence, the true pattern qualities, and ultimate design for the possibilities. So now the current progress AI, machine learning, big data analysis change all the IP practice. On technology and intellectual property aspects are forcing the legal profession to adopt. So artificial intelligence, machine learning, big data analysis, automations, privacy, data security for virtual lawyers. Now it's not only ChatGPT could support student to write a report, support a lawyer for preparing their cases, but patent drafting, smart contracts, they have been done very well for AIs. Inventorship, ownership have been coming to a new dilemma whether AI could be the part inventor or owner. So nowadays, the trending applications through emerging technologies very mature on prior search, patentability determination, patent acquisition. We need AI help, patent assertion, patent intellectual property investments. We all need that. So we have to carefully think about our value. So it's always then can be all coded, or the analytic engine is better than our emotional human being. It's software always there, always on, and who will be liable for hackers. Anyway, so there are many questions and there are many improvements. So here is my presentation for today. We welcome question and answers, questions. If you have questions, I can answer here or later on. I can respond in email. So thank you very much for the time. Thank you for organizers giving me these opportunities. Thank you.